I think I'm going to need a bigger coffee cup. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, these motion to suppress documents for the Franks motion and all of the freaking poison fruit that we're being told about in the Idaho 4 case. Now, we talked about the Amazon information. We've talked about the IGG information, which is the base. That's the tree. Okay, now we're on piece of fruit number 2, which is the apartment warrant. Now, I've mentioned this quite a few times. I mentioned it in the Amazon video whenever it got brought up in parts of that information, that the apartment warrant for Bryan Kohberger has a lot of problems, because it's sort of where I got the first inkling that the DNA was going to be a big problem in some way, shape, or form in this case. Now, I'm going to pull up the warrant and I'm going to show you exactly what I'm talking about. I'm going to do just like we did in the Amazon one, where we go through the original warrant first before we start going over the motion to suppress, just so that we have a nice refresher. Okay, so these are not going to be on the Idaho Case of Interest site. Most of you guys will know that this is actually separate information. The New York Times dropped a huge 166-page file way like 2 years ago on this case, and it contained a bunch of the Washington information, along with a lot of paperwork that we went over when it comes to evidence that was collected from his apartment whenever they went and checked out his work office at the university. We also have Blaker's PCA in there, you know, the copy and paste boo-boo that they've been talking about a lot in this case so far. And it's also how we know that Don Daniels asked for the DNA information to be excluded from the decision-making process when it comes to actually approving these warrants, and also how we found out she misplaced some DNA information for like 10 days and didn't do literally a damn thing about it until Ann Taylor showed up at Bryan Kohberger's apartment. This is page 39 of that 166-page drop, and it is the Don Daniels search warrant for Bryan Kohberger's apartment. Now, I'm not going to go over the entire thing. I'm going to just show you that she has this written out her way with their format, and then whenever you get down here to this last page, you see where it states supplemental disclosure regarding DNA test. This is the important part I'm going to be reading to you guys for this very specific motion to suppress, but it also very much intertwines into the poison tree, i.e. the IGG. I have been informed by Detective J.R. Talbot of the Idaho State Police that on November 13th, 2022, a sheath was recovered at the King Road residence under or next to the body of Madison Mogen. The Idaho State Crime Lab obtained a male DNA profile, suspect profile, from the sheath. This is also referred to in Sergeant Blanker's sworn statement, which again is in this drop, and I will, as always, have the link for these 166 pages down in the description box. On December 27th of 2022, law enforcement agents, officers in Pennsylvania, recovered trash that originated from the Kohberger family residence. That trash was sent to the Idaho State Crime Lab for testing. On December 28th of 2022, the Idaho State Lab reported that a DNA profile was obtained from the trash. It was compared to the suspect DNA profile. The lab personnel concluded that the source of the trash DNA profile was a male and was not being excluded as the biological father of the source of the suspect profile. At least 99.9998% of the male population would be expected to be excluded from the possibility of being the biological father of the source of the suspect profile. This information is being provided to the court pursuant to my duty and obligation to be fully candid with the court. I do not believe this information is exculpatory for the suspect. However, if the court believes it is exculpatory, then the court should consider this supplemental disclosure in its evaluation of the existence of probable cause or lack thereof. But I am specifically asking the court to not consider this supplemental disclosure as evidence supporting the existence of probable cause. They do not want the fact that there was trash taken from his parents' house that showed to be the biological father of the DNA profile that was found on the knife sheath. They don't want that being used as support for probable cause to enter his apartment. That is the most direct thing that they have, and they are not wanting it being used. Why? Oh, she gives us an answer. The reason for this request is that if the DNA test results are held inadmissible at some point, such a ruling would not impact the finding of probable cause for this warrant, so long as this court is satisfied as to probable cause regardless of the DNA test. And let's also just let you know, all she did was take whatever she was told from the sworn statements that she got from Blaker. That's it. She took Blaker's statement as Exhibit A, read through it, and talked to whoever this ISP guy is, Detective J.R. Talbot, and then wrote up her own report based off of somebody else's information, and then is asking for this very important direct actual connection to be excluded from supporting probable cause. Why in the shit would you do that? Odd, right? So now we're going to get to the actual motion to suppress, and it is regarding the search warrant for defendant's apartment. I am so super hoping that everything that I just said to you is mentioned in here. Comes now Bryan C. Kohberger by and through his attorneys of record and submits the following motion and memorandum in support of an order suppressing all evidence gathered by law enforcement as a result of the search of his apartment located at 1630 Northeast Valley Road, G201, Pullman, Washington. Let's also remember that whenever they were there, they also ended up getting on the phone with the judge and getting a warrant approved over the phone to go into like a little shed type thing that was also assigned to that apartment number. There wasn't anything in it, but I also kind of don't believe that they waited. I think they probably popped it open and then got permission, handled the situation off camera, and then turned the cameras on. That's how I sort of feel about it, but that's neither here nor there. The motion and documents in support of a Franks hearing are hereby incorporated into this memorandum. It's the same thing as the other one. I'm pretty sure they're all going to be like this. It is not going to be the exact specifics, but it's going to be the walk-arounds, and everything that is specific is going to be submitted on Monday, November the 18th, in person. That's what we've been basically told so far. Issues. And again, their base issue for every single one of these is going to be that these are pieces of fruit that are being picked off a very poisonous tree, because their base argument is that Bryan Kohberger's DNA was illegally obtained. And when I tell you that that is the base part of my theory here, these damn documents get me hyped. This court should apply Idaho's exclusionary rule and law to this search. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. The affidavit submitted in support of the application for the issued search warrant included information that must be excised. And here comes their base fight. All information in the affidavit was gathered because of law enforcement's unconstitutional use of IgG, and thus nothing in the warrant should remain. Information about the client's locations taken from his phone must also be excised due to being gathered from an invalid warrant, and let me tell you why that's wild. That information, the freaking client's information, y'all, is what? Exculpatory. Okay. According to Cy Ray, the cell data in the discovery that was given to the defense that he had the privilege to look at himself, he got on the stand pro bono for the defense for the first time in 20 years after putting nothing but bad guys away time after time after time after time again, and said, the cell data that I've seen is exculpatory to the defendant. And even though it's exculpatory to their client, They want it taken out of the case. That is wild. Has anybody ever seen that before? Because that just doesn't seem normal. But if they're trying to keep theme, exculpatory or not, it's fruit of the poisonous tree and it shouldn't even be there, even though it would apparently be good for their client for it to remain. Interesting argument. This is going to be good because this is a bunch of dates and case facts. Okay. Due to the haphazard way in which law enforcement has kept and disclosed records in this matter, the following are the facts relating to obtaining the search warrant for 1630 Northeast Valley Road, G201, Pullman, Washington. On December 28, 2022, Trooper Leary of Pennsylvania State Police became aware of the objective of arresting Mr. Kohberger via Moscow Police Corporal Payne. On December 29th of 2022 at 4:45 p.m. Eastern Time, a magistrate in Pennsylvania issued a search warrant for Mr. Kohberger's person, for his body, not his car, not his parents' house, for his actual old self. On December 29th, 2022 at 2:22 p.m. Pacific Time, the magistrate in this matter signed an arrest warrant for Mr. Kohberger in Latah County. The affidavit for the warrant was signed by Moscow Police Department Corporal Brett Payne. The basic facts Payne used to support the search were: next to the body of Maddie Mogen was a tan leather knife sheath. The Idaho State Lab later located a single source of male DNA on the button snap of the knife sheath. Footage from the King Road neighborhood showed what the police suspected was the vehicle of the killer. This white sedan lacked a front license plate. A vehicle specialist decided based on the footage that the vehicle was a 2011 to 2016 Hyundai Elantra, but he didn't at first. At first, they didn't even think it was a Hyundai. So we're not even going to go through all that again. There's a video on that one. A vehicle matching that description was spotted via surveillance in Pullman and also was like part of what was going on at the Banfield at the original time frame of the crime. Let's just remember that part. It was later discovered that Mr. Kohberger drives a 2015 Hyundai Elantra and that he lived not far from the last place a white sedan was seen driving in Pullman over an hour later. The same specialist indicated the car seen in Pullman was a 2014 to 2016 Hyundai Elantra. But when? After they already had Bryan's name or before? Because come on. Witness Dylan Mortensen had indicated the height of the person she saw at the time of the attack was between 5'10" and 6 foot. That is new because, and I'm going to go get it right now, the original affidavit does not say between 5 feet 10 and 6. It says 5 feet 10 and taller. I just looked at it yesterday. Is this the right one? I always end up the wrong one. Okay. Where it be? Okay. Went to her room and slept and blah, blah, blah. Right here. 5'10" or taller. Not very muscular, but athletically built with bushy eyebrows. So them giving a cap at 6 foot, that's new. Police determined Mr. Kohberger fit that description. I want to know if Dylan ever pointed him out in a lineup and photos. Like, I want to know. Records from August 21st of 2022 traffic stop showed Mr. Kohberger was the driver of a white 2015 Hyundai Elantra with Pennsylvania plates lacking a front plate. It also showed he had the phone number of 509-592-8458. He noted investigators learned that this was an AT&T number. Mr. Kohberger had changed his vehicle registration to Washington on November 18th, 2022. Cell tower records did not show Mr. Kohberger was in Moscow at the time of the murders. In law enforcement's experience, however, people committing crimes typically turn off their phones, while smart people committing crimes that have studied this stuff for a decade would have never taken his phone from his apartment, but that's whatever. Historical cell site location information, or CSLI, was obtained and given to a cellular analysis survey team, CAST, with the FBI. Again, the FBI being a part of the investigation. How is the IGG a tip? It's not. That team determined that on November 13th, 2022, at approximately 2:42 a.m., Mr. Kohberger's phone was utilizing cellular resources that provide coverage to his apartment in Pullman, Washington. They support the idea that he left his apartment and went south. They supported the phone being off. They support at 4:48 a.m. that the phone is south of Moscow, Idaho, near Blaine, Idaho. But we've also learned a lot about how towers can back jump. The phone utilizes resources that make their way back to Pullman, coinciding with a white Elantra seen on some surveillance there. A similar data showing occurs at approximately 9 a.m. with a trip into Moscow and returning at around 9:32 a.m. The same team determined Mr. Kohberger had been to Moscow on at least 12 occasions prior to the event and that he came into the area the morning following the murders. See, that one in the PCA is the one that has really gotten my attention. Or at least it did until I found out how much crap this damn cell phone stuff was, because it claiming that he left his apartment at a certain time, got over there, and then got back to his apartment at a certain time, meaning that he stuck around King Road for 10 to 12 minutes. That was very specific. And whenever there were rumors in the case that a bunch of people knew before the 911 call was made, I was like, damn, could he have just been one of those people that maybe were told ahead of time and he was just over there being nosy like some people probably would be that are into crime stuff? I don't know. I found it very specific, and I was kind of hoping that the rest of it would be just as specific so that it played more of like the role that the evidence was supposed to actually play. But again, according to Ray, nothing that came from his cell phone data puts him there. It's all exculpatory. That's why it's kind of crazy to me that they're wanting to suppress it. However, law enforcement without explanation indicated it did not believe the final trip ever occurred. And that's talking about how the PCA mentions there's another ping, but that they don't believe that he was really over there. So even in the PCA, they're giving margin for error by putting that little fact in there by saying, yeah, there was another one, but we double checked it because we're good like that. And these other ones are legit, but that one, it wasn't. So we're just going to let you know that we did that handiwork so that you believe these other ones are legit, because we've already told you that we've weeded out the wrong false pings. That's basically what that whole thing was about. At 2:43 p.m. Pacific on December 29th of 2022, a criminal complaint and probable cause order were filed in this matter. At 10 p.m. Eastern, Pennsylvania SWAT began preparations to arrest Mr. Kohberger. Despite days of constant FBI surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15 p.m. Eastern. And despite the fact that the constant FBI surveillance showed Mr. Kohberger was unarmed and tended to go for runs around his parents' neighborhood, police decided that in the dead of the night, or within his parents' home, I don't know what word was supposed to be there, maybe breaking into his parents' home, going within his parents' home, whatever. Basically, they're saying he didn't have a weapon. He went on runs by himself in the neighborhood all the time. There was no reason for them to have busted up into the house like that whenever he was alone, and they could have arrested him at any moment, is basically that argument, which I agree. Why make it like a huge spectacle and then claim it's not on freaking body cam? That's kind of stupid. But then again, if they arrest him outside of his house, they probably have to go through bigger hoops to get inside the house to do an actual search warrant. And if they just bust in the house in the middle of the night and all the confusion, maybe something can be put there that's not supposed to be there. That's just where my mind goes with it, because, yeah, that argument makes a lot of sense. At 9:25 p.m. on December 29th, a Superior Court judge in Washington issued a warrant for Mr. Kohberger's apartment in Pullman, Washington. That warrant was based on the affidavit of Assistant Chief Don Daniels of the WSU Police Department. I don't like you, girl. That affidavit shows that Sergeant Blaker of the Moscow Police Department requested the assistance of the WSU Police Department in investigating this case. The affidavit relied on the same information outlined above, and we have a footnote. There was a supplemental section. Oh, I love it. So they're mentioning it. Okay. There was a supplemental section to the affidavit indicating DNA of the father of the person whose DNA was on the sheath had been found in the trash at Mr. Kohberger's parents' home. However, the Superior Court judge specifically did not rely on that information in determining probable cause. Well, we don't know that. They were just asked not to, you know. On December 30th, 2022 at 1:14 a.m., Pennsylvania SWAT and federal agents raided Mr. Kohberger's that's probably the word right there. To raided within? Maybe it's still not the right word. I don't know what it was. Okay, anyway. Pennsylvania SWAT and federal agents raided Mr. Kohberger's parents' home. Law enforcement arrested Mr. Kohberger. On December 30th of 2022, Idaho State Police, Moscow Police, and other law enforcement searched Mr. Kohberger's apartment at 1630 Northeast Valley Road, G201, Pullman, Washington. And I will just say now that according to the evidence logs of things that were looked at, taken in, whatever, that are in that 166-page drop, the couple of things that were blood, that did test positive for blood, they're still claiming that there's no connection. So whatever it was, the blood didn't belong to Kaylee, Maddie, Xana, or Ethan. For all we know, it was difference in climate and he got nosebleeds, cut himself shaving. I mean, it could literally be just that simple. Argument. This court should apply Idaho's exclusionary rule and law to this search. The first question this court must determine is whether there was a conflict of laws in this matter, i.e., whether Idaho law or Washington law controls the validity of the search warrant for Mr. Kohberger's apartment and the necessary relief. Unlike the issue of arrest warrants, cases involving multi-state investigations have produced far less case law. In fact, the defense could not find a precise case on point for the state of Idaho. So they really can't reference anything that's actually specific. Okay. The issue, however, has received some attention in academia. Professor Kerr argued in his article for the Harvard Law Review that the jurisdiction where the crime occurred should control how the investigation is done, but that states and or the federal government should provide some form of authorization to each other to participate in each other's criminal investigations. As it stands, there are at least 5 different approaches to this increasingly common situation. Fortunately for this court, Idaho and Washington do not differ in their approaches to the enforcement of their Fourth Amendment analog provisions. Both do not accept the good faith exception. However, it is also clear from the grounding of the exclusionary rule in Article 1, Section 17 that evidence obtained in violation of the Constitution must be excluded. Thus, Mr. Kohberger argues that the Idaho Constitution's exclusionary rule must apply, as its basis lies not only in deterring police misconduct, but because exclusion is constitutionally mandated and judicial integrity demands it. However, it remains to be determined whether the actions of the FBI and WSU police should be viewed through the lens of Article 1, Section 17 or its analog. It is not at all clear whether a search should be judged by Idaho standards of reasonableness or that of Washington, or in the case of the FBI agents, by the Fourth Amendment. So they don't know who has control over which laws should have actually been adhered to. And the fact that they're all different is the stupid part. As noted, Professor Kerr would have Idaho's reasonableness apply in that the FBI and the WSU police were acting under its authorization to investigate a violation of its laws. Correct, Moscow was supposed to be the lead. Just because FBI was helping, though, that's still... technically, they're like the more authoritative, but unless they took over completely, even though it sounds like they did with the way that everything is going here, they left Moscow as being labeled the lead. So I guess it would be Idaho. This approach would also mesh well with older cases such as U.S. versus Dire from 1948, dang, that's old, looking to the laws of the state where the defendant was arrested in the absence of a federal law permitting the arrest by a federal agent for a federal law violation. See, that sounds like the feds would be in control of that situation. I don't know. Okay. It also goes along with the legal framework of agency. In this matter, Idaho authorities requested assistance from the FBI and the WSU police. This is true. Assistance in the investigation. So, therefore, anything is not a tip. I'm just going to keep saying that. Thus, this court should be required to apply Idaho's search and seizure laws to their actions in Washington. However, this concept has its detractors. McGlynn argues that when the CITES officer is performing the search, they should only be held to upholding their own laws. While that position has merit, as it does not require a CITES officer to get a rundown of the differences between their law and the trial state's laws, it remains that the Idaho Constitution is not merely concerned with deterrence to officers who misbehave. Moreover, it is of concern that such a rule would permit forum shopping. After all, if Idaho's law enforcement may take advantage of laxer restrictions in a different state, they may simply pause their investigation until their suspect is in that new jurisdiction, or in the case of the FBI, state law enforcement could at any point, even within Idaho, call upon federal agents with the far laxer rules of the Fourth Amendment. That's interesting. You can't do it. There's certain laws you can't break, but you know damn well who can. And that's why you let them do it. And that's why we have no case. There we go. Finally, it must be said that there is very little daylight between the Idaho Constitution and the Washington Constitution. If anything, Washington appears to have stricter requirements for probable cause. Okay. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. I am wondering if there's going to be any difference in this, because so far it looks like the exact same literal everything for this portion of this argument that they placed in the Amazon one. And I do feel like a lot of this type of stuff for this argument is going to be the exact same stuff, minus like the very ending of it, because that's where we did get a little bit more specifics. Let's see. But they are basically just claiming that exculpatory information was definitely omitted, and we've known that. They've talked about that for a really long time. They don't have a specific in here. It just ends with the challenge pursuant to this section of the motion is separately laid out in Mr. Kohberger's motion for hearing and Frank's. The motion and proffer are incorporated but not repeated. So yeah, they're not putting specifics in this one, but it'll probably be delivered on Monday and it's going to be sealed, so we're going to have to wait. And then they go to their base fight, which is that the IgG came from illegally obtained DNA and it should be completely gone, and it just same thing as before. Mr. Kohberger has argued in a separate motion that the genetic genealogy investigation in this matter was done in violation of the Constitution. And there's no difference here whatsoever. Everything is exactly word for word, exactly the same. Okay, this is a little bit different. Information about the client's locations taken from other illegal searches must also be excised due to being gathered from invalid warrants. Separately, the information gathered via the warrant for Mr. Kohberger's AT&T account and the pin trap and trace device warrant should be excised for the reasons set out in those warrants. Those ones are coming. We have to go through Apple and then the arrest warrant, and then they have the first warrant for the AT&T, the cell phone data, and then Google and pin trap, and then we keep on going. So they are going to be obviously talking about the other ones in these, even if we haven't gotten to them yet, because I am trying to go through them in the orders that they were posted, which was the good idea considering that the genealogy is the tree. It is the poison tree. So I'm glad we started with that one. Other excision should be applied in accordance with the other motions to suppress filed contemporaneously. Conclusion, Mr. Kohberger requests this court suppress all evidence obtained by police via the warrant that permitted them to search his apartment, even though they've said in court, no connection, meaning the hairs that were found had nothing to do with the 4 people that died. The blood that was found, no connection to the people that died. That matters a lot when it comes to these, because it sounds like everything that could be good in Bryan's favor based off of what we know so far is what they're sort of asking to be excluded here in this one, especially in this one. As explained above, the warrant lacked probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusions, and because the warrant omitted exculpatory information and information that put into question the reliability of the facts upon which it relies, and finally, because the affidavit relied on evidence gained in violation of the Constitution, all in violation of the Fourth Amendment and Article 1, Section 17. They're probably all going to end just like that. And again, same as before, they're giving like a precursor to what's going to be handed in on Monday in person. I mean, honestly, I kind of like the fact that they're being like, they didn't show their work, because didn't Hippler basically just say the exact same thing to the defense team whenever they asked for that motion of leave? And he was like, this is a naked motion. You're giving me nothing here. You're giving me no details. And it was basically just a big show your work denial. So maybe Judge Hippler will apply that here too and make the state actually prove their case, because if he's going to be a fair judge, he can't sit there and say that kind of stuff to the defense and then see how lackluster all this crap is and not expect the state to be told the exact same thing. Show your work. Where's your work? Okay, well, then you need to be doing a better job at getting the work from the feds, or what are we here for? Where's your case? You have nothing. Hopefully Judge Hippler is the right kind of judge for this, and he gives the state the same thing that he has just recently given the defense. But we shall see. Let me know what you guys think about this down in the comments. We've got a lot more to go. A lot more to go. Like I said, the one previous to this was about the IGG and the Amazon warrant. And the next one is the Apple warrant, and it's 20 pages. So I'm excited to see what they have in this one, because like I said, it's kind of strange that Cy came out and said, hey, all the cell data so far that I've seen is exculpatory to Bryan Kohberger. And they're wanting to suppress things that are good for their clients. That's, I think, my biggest loop-de-loop right here. But let me know what you guys think about that down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already. And please make sure to have that notification bell set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.